Hello and good morning friends, welcome to the CEC live lectures. Dear friends, as you know that we are carrying a series on copyrights, and in previous session we discussed in detail what copyrights are. It was an introductory lecture and we believe that you might have watched the lecture on YouTube too. So as usual, we would like to tell you all that you can give your feedbacks always on info.cec@nic.in. So friends, taking the series forward, today we are going to talk on subject matter of copyright. And for this discussion, we have once again with us in our studios Mr. Ashwini Siwal. Mr. Ashwini Siwal is an assistant professor in the Faculty of Law, University of Delhi. Mr. Siwal has immense experience. He is a young and energetic professor who is contributing a lot in the area of academics. He believes in giving the maximum of his knowledge to the students. That's why through this EduSet, that is live lecture platform, he gives the most of his knowledge to you. So friends, if you want to ask questions from Mr. Ashwini Siwal on today's topic, that is subject matter of copyright, then you can call right in the CEC studio. You can contact us through our toll-free number. Our number is 1800 430. I repeat, our number is 1800 Friends, you are requested to call in the last 10 minutes of the lecture so that the lecture goes uninterrupted. So now I would like to welcome our guest, Mr. Ashwini Siwal, once again. Hello sir, welcome to the lecture.
Thank you very much, Geetika. Good morning viewers. This is the second lecture on copyright. In the previous discussion we talked about the introduction to copyright, and there are certain important areas that we saw and discussed in the previous discussion. To recapitulate quickly about the previous discussion, there were three things that I covered in the previous discourse. I talked about the historical evolution of the copyright. I talked about the cursory important things in the copyright law, and I talked about different things that are getting covered under the copyright law. Today in our discussion we will specifically focus on subject matter of copyright. And dear friends, as you all know, that it is very important to know what all can be given the protection under the copyright law. By subject matter I mean, and I refer to the different things that can be given protection under the copyright law. Many of you might be having the superficial idea or maybe having the concrete idea as to what all can be given the protection under the copyright law. Well friends, in common parlance we understand there are so many things that can be given the protection under the copyright law. For example, we all know that our literature can be given a copyright protection. We all know that our cinefilm can be given a copyright protection. We know that a photograph, a painting can be given a copyright protection. But in today's discussion, dear friends, we are going to restrict our discussion specifically on the subject matter of copyright in legal parlance, and that too by referring to the Copyright Act 1957. In India, we have the legislation called the Copyright Act 1957 that talks about the subject matter of the copyright, and it explicitly tells us on what subject matters the copyright subsists. So let us start our discussion, friends, and have a look on the different kinds of things, variety of things on which copyright protection can be conferred, and a person seeking a copyright protection can approach the copyright board for getting the protection on those different things, subject to certain conditions, of course. Well, those conditions I may take up in my later discourses undoubtedly, but keeping in mind that there are some qualifications to be fulfilled, notwithstanding that you have got a subject or a work which qualifies to be given a copyright protection, you will still have to fulfill the requirement of, the substantive requirement of getting the copyright protection, and that is also provided under the Indian Copyright Act 1957, friends. So let us have a look on the different subject matters of the copyright, and for that, or before commencing directly the list of the things that are given under the Copyright Act 1957, let me tell you friends, copyright lies in expression. Copyright lies in expression. You might be watching the slide and it is clearly written here that copyright lies in expression. Well, contrary to that, let me tell you, copyright does not lie in an idea. Well friends, you have to understand the distinction between idea and expression. as far as the law goes, it demarcates and it simply says that copyright lies on an expression, it never lies on an idea. But so far as the distinction between these two terms are concerned, nowhere in the Copyright Act 1957 the distinction has been explicitly provided or demarcated. But by our general understanding and by the help of the different case laws on these different expressions and on these different concepts, we get to know that something which takes a shape of the expression by referring to an idea is called an expression here, or something which is portrayed, something written on some topic, that is called an expression in this case. Though there always lies a tussle or a conflict in understanding the idea and expression, or the clear distinction between idea and expression. But for your convenience, friends, let me take one example that may throw some light on the distinction between idea and expression, or maybe will be helpful for you to understand what constitutes the idea or what constitutes the expression and what can be called the idea. I am a teacher of intellectual property, friends. So suppose I, being a teacher of intellectual property or a researcher in the intellectual property field, I want to write something on intellectual property. So my idea is to write something on intellectual property. While I will write something on intellectual property, the expression has to be mine. Are you getting it? It means that expression in which I will be expressing myself on that particular topic, that has to be mine. If I am taking an idea of writing a book from a renowned author, it will not make any difference and nobody can stop me from writing a book on one particular topic or one particular discipline. But the expression in my work has to be my expression, it must originate from me. If it is something which is copied, then in that case I may be held liable for the offense of infringement, or in the case of educational copying, I may be held liable for plagiarism as well, which is unethical thing in the academics, or which is unethical thing in the education. My dear friends, so far as idea expression is concerned, let us take one more example to understand it. Suppose there is an idea in the mind of a photographer to click the picture of a wild animal. Any photographer who is interested to click the picture of wild animal can click the picture of wild animal or the wildlife without any hesitation. But the idea of clicking the picture is not to be given as a copyright protection to one individual. If the copyright protection is given to one individual for clicking the picture, or in the previous example for writing a book on IPR, other authors, interested people in writing the book or in clicking the pictures will be deprived of writing the book or clicking the pictures of the wildlife respectively. So for that, you see, you have to understand that things which are there, which can be given the copyright protection, or the different ideas which one wants to express, people are allowed to express in any manner whatsoever, but that must originate from the person. Ideas can never be given the copyright protection. On the contrary, if you look at the patent law, my dear friends, in the case of the Indian Patent Act, the distinction that lies between the Patent Act or the patent regime and the copyright regime is that in the case of the patents, even the ideas can be given the protection under the patent regime. But under the copyright law, it is only the expression, the way you have written it, the way you have clicked the picture, the way you have done some act or a performance. Performing on a song, performing on something is not prohibited. The idea of performance, the idea of writing, the idea of delivering a lecture, the idea of writing a book on a discipline, the idea of clicking a photograph, all these things are mere ideas, and nobody can be given a monopoly on the ideas or on such things which others are also allowed by purview of the Copyright Act. But the requirement for fetching the copyright protection is that one must show some originality in the work, and one must do some efforts and must apply the skills or ingenuity in creating the work, and the work must originate from the person. The work must originate from the person. So origination of the work is the sine qua non, not the idea. So my dear friends, there can be different expressions coming from a human being. if I ask you to write a poem or a note on something, and similar work is assigned to your friend, for example, you will come up with your expression, your friend will write the same issue or the same thing in his own expression. So expression has to be yours. I mean, your friend and you both will be given the copyright protection on your different expressions. Nobody will be denied if there lies a original expression in the respective works. Ideas, so therefore, are not protected. Only the expression in the copyright is protected, my dear friends. Now coming to the difficult part to understand, that is how to differentiate between idea and the expression, and when does one idea takes a shape of an expression. It becomes very difficult to finalize and to analyze as to when an idea is taking a shape of an expression and when something which is claimed by the owner of the work as an expression is a mere idea. So there always lies a dichotomy in the idea and expression, but this dichotomy between idea and expression has several times been discussed by the courts of law in the country and have already been deciphered by the courts in the country. The interpretation of the idea expression dichotomy has taken by the courts in India in several judgments of the court, which we will take in our later discussions while discussing about the idea expression dichotomy specifically, my dear friends. Now moving ahead, if you look at the today's discussion where we are discussing about the subject matter of the copyright, friends, as far as Indian Copyright 1957 is concerned, under section 16 of the Copyright Act, it simply says that the copyright will lie only in the works for which copyright can be conferred under this act, not on any other thing. So the law has made it clear, the legislation has made it explicitly clear and categorically clear that the work will be given the protection only if that work falls within the purview of the Copyright Act, and on no other thing the copyright shall prevail, or no other thing will get ever the copyright protection under this act. So let us have a reading of the language of section 16 as provided on your slide. It reads that no person shall be entitled to copyright or any similar right in any work, whether published or unpublished, otherwise than under and in accordance with the provisions of this act or any other law for the time being in force, but nothing in this section shall be construed as abrogating any right or jurisdiction to restrain a breach of trust or confidence. So my dear friends, this section categorically clears it that the copyright shall be given only on those things which have been made subject matter of copyright under the purview of the act. Moreover, it has to be conferred in accordance with the provisions of the act on an unpublished or a published work whatsoever, but the point is that it has to be conferred in accordance with the provisions of this act. If there will be a copyright on something in violation of the provisions of this act, in contrary to the provisions of this act, then that kind of a copyright will not be recognized by purview of the Copyright Act 1957. So for us here at this juncture, it is very important to understand that copyright lies only in an expression. First of all, the subject matter of the copyright will be expression, it will never be the idea. And the second important thing for us to understand at this juncture is that the copyright shall be given in accordance with the provisions of this act on the subject matters or on the things which are brought squarely under the purview of this act, and on no other thing, So now let us see what all has been made explicitly the subject matter of the copyright under the Copyright Act 1957 in India. So friends, before that, let us take one more definition, because it is also essential to understand the definition of the work, because whatever has been defined as the work in the copyright legislation is given the copyright protection and can be called the work for the purposes of conferment of the copyright protection. So work in the copyright law means a literary, dramatic, musical or artistic work as defined under section 2 and subclause Y. Section 2 is a definitional clause under Indian Copyright Act 1957, which provides definitions of different terms, and the reference to those terms will be construed accordingly throughout this legislation, my dear friends. So work in the following works under the Copyright Act means, or namely, a literary work, a musical work, artistic work, a cinefilm, or a sound recording. These are the things on which a copyright can be conferred, because these are the works in which copyright lies according to the definition and according to the Copyright Act. Moving ahead, friends, now coming to a specific provision which talks about the subject matter of copyright, that is section 1.3, that is section 13 of the Copyright Act, my dear friends. And section 13 is the most important provision to my understanding of the Copyright Act, apart from some some other provisions which are of importance. But section 13 gives you the list of the things on which copyright can be given and in which the copyright subsists basically. So let's have a look of the things on which copyright can lie and can be given under section 13. If you see the list jotted down here on your slide, copyright subsists in artistic work, in dramatic work, in literary work, it lies in musical work, it lies in computer programs, my dear friends, it lies in cinefilms, and it lies also on sound recordings. These are the works which have been covered explicitly by purview of section 13, under section 13, and these are certain categories of works in which copyright can be given and copyright can subsist. Now, you see, these are broad terms used here: artistic work, cinefilms, you see, literary work, dramatic work. The definitions of all these broad terms are provided under the Copyright Act 1957 itself. The definitional clause under the Copyright Act, that is section 2, provides us the definition of all these different variety of terms and the works on which copyright can lie or on which the copyright subsists. Let us have a look of the different works and their definitions, their further elaborations and elucidations, to understand them more appropriately. If you look at definitions of various works and the relevant provisions under which those definitions are provided, so my dear friends, the definition for the artistic work is provided under 2C. The definition for dramatic work is provided under 2H. The definition for literary work is provided under 2O, and the definition for a musical work is provided under 2P. The definition for computer programs under 2FFC, and the cinefilm is provided under 2F, and the sound recording in last is provided under 2XX. Well, my dear friends, before I jump straight away to interpret these definitions and to decipher these definitions in consonance with the definitions of these terms provided in the definitional clause, I would like to first tell you that under section 13, if you look carefully, the copyright shall subsist. There are three sub clauses under subsection 1. Under section 13.1, A, B, C is given, and under section 13.1 A, you will find the primary works on which copyright lies. For example, the copyright subsists according to section 13 in original literary, dramatic, musical and artistic works. But under section 13 subsection 1 clause B and C, you will find that there is a mention of derivative or secondary works. For example, cinefilms and sound recordings. Why I have mentioned that these are derivative or secondary works vis-a-vis to the primary works covered under section 13 subsection 1 clause A, my dear friends, there are two categories of works which have been or which can be conferred a copyright protection by purview of Copyright Act 1957. These are as follows: the primary works and the secondary works, or you may call the derivative works. Well, as far as the primary works are concerned, primary works are those works, my dear friends, on which copyright can be given and primary works are those works, if we define primary works, are those works which are creations of the people or their ingenuity or their mind, and the works are such which have never existed earlier. Primary works are those works which have never existed earlier, or those expressions have never existed earlier. That is why they are called primary works. And those primary works have been made the subject matter of copyright under 13 subsection 1 and clause A. But on the other hand, the derivative works are also works to be given and tenable to be given a copyright protection. But the difference of the derivative work vis-a-vis to the primary works are that in the case of derivative works, it is not necessary that the derivative works are the offshoots of the human mind for the first time, or maybe for the first time expressions are there. Derivative works are those works which have been created by referring to different other works. That is why they are called secondary works also, because there already lies a primary work from which the derivative work has come into the existence, or by reference to the primary work, a derivative work or a secondary work has come to the existence. That is why they are called derivative, or synonymously the secondary works under the copyright law. But on both, a copyright protection can be conferred as defined under section 13 subsection 1, that a copyright shall lie on artistic work, dramatic work, literary work, musical work, cinefilms, sound recordings. If you look at this slide, friends, which provides different works on which copyright can be given, on the first four, a copyright can lie because they are primary works. They fall into the category of primary works. Artistic work, dramatic work, literary work, and musical and computer programs, they all are primary works. But the last two works mentioned on this slide, or last two subject matters mentioned in this slide, are the derivative or secondary works. They need not necessarily to be primary works. Well friends, now moving ahead to different definitions or the further elaborations of these following categories of works, I have to refer to the definitional clause, that is section 2, and under section 2C, artistic work is defined. According to section 2C, artistic work means a painting, a sculpture, a drawing, including a diagram, map, chart or plan, an engraving or a photograph, whether or not any such work possesses artistic quality, work of architecture, and any other work of artistic craftsmanship. Well, my dear friends, if you look at this slide, artistic work is itself covering so many things and including so many things. It even includes a painting, a sculpture, an engraving. It includes even a photograph. A photograph is also an artistic work. It may be, a surprising thing for you to note that a photograph can also be given a copyright protection, but you have to identify the category under which you will seek the copyright protection. So copyright protection for a photograph and the category under which the copyright protection for a photograph will lie is artistic work. Similarly, you see, for a sculpture, for a drawing, for a painting, all these things are called artistic works. Another noticeable thing, my dear friends, if you look at this slide, the last part of this subclause 1, which reads, whether or not any such work possesses artistic quality. Well friends, it makes it amply clear that artistic quality, aesthetic quality is not at all required to get the copyright protection on an artistic work or on following artistic works. It is not necessary that your work must have some artistic quality. It is not necessary that the photograph clicked by you must have or must possess some good features in it, or the sculpture created by you must have some artistic merit in it or artistic quality in it. A painting need not be a very good painting or a painting of artistic quality or merit. It may be any painting, but it has to originate from you. If it is originating from you, and if there is originality in the expression, that work will be given the protection because it is an artistic work and it is something which is liable to be given or thrown the protection under the copyright law, notwithstanding any kind of a artistic quality involved in it. So my dear friends, you should not worry while creating your works for the want of any kind of a quality or artistic quality. You will never be prohibited or denied the copyright protection. Mind it, for the want of artistic quality, for the want of any artistic merit, your work will never be restricted or prohibited to get the copyright protection. You will be given the copyright protection like any other excellent painter or like any other renowned sculpturist or any other renowned photographer. So generate more and more works. The underlying thing that you have to take note of is that your work must not be copied work. It must originate from you and there has to be originality in your work. I am emphasizing on the term originality, my dear friends. I will discuss it later in my specific session on originality. Right now, if you look at the another thing that falls under the definition of artistic work is work of architecture. And the definition for work of architecture has also been provided under the definitional clause, which reads that a map of a building or plan of a building is also called work of architecture. So architect people must not be worried about their copyright on their works of architecture. So whenever they create any work, they always have a copyright on those works, but they cannot restrict any other person to express the similar idea in their own expression. That we have learnt in the very beginning of this lecture. The third thing that can be given the copyright protection is any work of artistic craftsmanship. Well friends, the work of artistic craftsmanship may include a sculpture also, a painting also, a drawing also, and a definition for artistic craftsmanship is also available under the definitional clause. So work of artistic craftsmanship are also given copyright protection under the category of artistic works. This is one category which we have discussed. After that we have 5-6 more categories under which copyright protection can be conferred, or a subject matter is there for which a copyright protection can be given. So let us just wrap it up quickly and understand what all under the category of artistic work can be given a copyright protection. A painting, a drawing, a sculpture, a photograph, a work of architecture, and finally a work of artistic craftsmanship are all eligible under the category of artistic works to be given a copyright protection. One important noticeable thing in this discussion, my dear friends, is that your work of painting, photograph, sculpture, drawing must not be such or must not be something which is copied, which has to be necessarily your work and it must originate from you. Another important thing, my dear friends, here to understand is that your work is not necessary to possess artistic quality or a merit in it. Thank you very much, friends. We will meet in the next session. friends, the next category in the subject matter of copyright is the dramatic works. On dramatic works, a copyright protection can be given. And friends, the definition for dramatic work is given under section 2H of the Indian Copyright Act 1957. Well friends, as far as the dramatic works are concerned, these are the following things which are included in the category of dramatic works on your screen, my dear friends. Dramatic work includes any piece for recitation, choreographic work or entertainment in dump show, the scenic arrangement or acting form of which is fixed in writing or otherwise, but it does not include a cinefilm. Well friends, if you look carefully on this slide, there are 4 different things mentioned over here which have been included in the category of dramatic works. Any piece for recitation, choreographic work or entertainment in dump show. Well friends, by the first appearance of the word dramatic work, what do we have in our mind and what do we perceive from the meaning of the dramatic work? We usually understand by dramatic work the portrayal of a cinefilm. We usually understand and perceive by the word dramatic work some dramatic performance of the performers, or sometimes we understand some acting of a person in a play or in a show will be called a dramatic work. But my dear friends, apart from these things, you see, the category of dramatic work includes so many other things also. But before starting the discussion on different things, let me tell you that this definition is inclusive definition, my dear friends, and the word include signifies and demonstrates that it is an inclusive definition. What does inclusive definition mean here? That it is not exhaustive, and many more such things can be also brought under the category of dramatic works and can also be called dramatic works which are not yet mentioned in this definition. But if there is something which squarely fulfills the requirement to be brought under the category of dramatic work, that thing can also be brought under the category of dramatic work because it is inclusive definition, it is not exclusive definition. Well, my dear friends, if you look carefully, dramatic work includes any piece for recitation, choreographic work or entertainment in dump show. Any piece for recitation. So the piece for recitation itself will be called a dramatic work because you see, one who has written it, he will get the protection on his work under the category of literary work. But one who is reciting it, that person will be given a dramatic work protection, or the protection to him would lie under the category of dramatic work because it is a piece of recitation by him. Moreover, on the similar thing, a performance rights can also be given to a person. A performer's right can also be given to a person because he is performing while reciting it. A choreographic work or entertainment in dump show. Well, dear friends, I believe and I am presuming that all of you understand what does choreographic work mean. A choreographic work mean, especially in the film industry, in the cinefilms, the different choreographies or backgrounds in the cinefilms that are basically the offshoots or the creations of the skills and ingenuity of the persons, and that are their expressions. You might have seen different songs in Indian film industry portrayed on different backgrounds or portrayed or demonstrated in different backgrounds. So those backgrounds, those sets in light of or in particularly in those circumstances the performers are performing, in those scenarios those performers are performing, they are called the choreographic works of the people. Even the dresses of the artist, playbacks, etc. comes or falls, the steps of the dancers, the synchronization between the dancing sequences, etc. all are called choreographic works, my dear friends. Or entertainment in a dumb show is also called a dramatic work. So entertainment in a dumb show means what? Any person is entertaining in a dumb show where there is no need of any audio, or there is no audio as such, but the entertainment lies in that dumb show by way of expressions of the persons, by way of different expressions of the characters of that particular show. So that is also called a dramatic work and comes under the category of dramatic work. The scenic arrangement or acting form of which is fixed in writing or otherwise. Well, my dear friends, you might have seen in the movies that there are some acting form which usually the actors in the movies follow. If those acting forms are written or are fixed in otherwise forms, they are called dramatic works, and the copyright can be given to those works. That would depend who can be called the owner. It depends on certain agreements or in some other different situations. We will have to determine as to who will own that copyright, but the performer will undoubtedly get the right of a performer on that performance, which is a scripted performance or which is scripted in a writing or in some otherwise manner. Well, the scenic arrangement, the acting form, all are called the dramatic works. My dear friends, the last category is not the inclusion, it is the exclusion of one kind of specific work to be called the dramatic work. It simply reads that it does not include, the dramatic works does not include cinematograph film. Well, the cinematograph film will fall under a separate category that is called a category of cinematograph films, and you can call a cinematograph film is a derivative work. So that category is a separate category, and for that a separate elaboration is provided. That is why it has been excluded to be called a dramatic work, and the entire cinefilm can never be called dramatic work. It is the performance of the person, it is the choreographic arrangement, scenic arrangement, acting form, written or otherwise, that comes under the category of dramatic work. The entire cinefilm, which is a cumulative effort of different people engaged in the making of the film, cannot be called a dramatic work. That will remain a cinefilm. And cinefilm, the difference in the cinefilm and the dramatic work is that cinefilm is basically a visual capturing of the images, or sometimes audio capturing accompanied with the visual capturing, also called a cinefilm, and it comprises so many different things in it. So there is a separate category under the category of cinefilms, and for that there is a separate protection available and a separate definition is provided. Now jumping to the next category, friends, that is the category of literary works. It is one of the most important categories here of the literary works. The definition for a literary work is provided under 2O, and it reads, well, my dear friends, literary work includes computer programs, it includes tables and compilations, including computer databases. Well, my dear friends, if you look at the definition of literary work, it is also an inclusive definition, as the word includes is written here. But my dear friends, you will be surprised to note, and you might be thinking by now, that how can computer programs which are basically considered technical things be called literary works and be given a protection under the literary works? Well, my dear friends, literary work is a category which is usually taken into consideration, and which is the most referred category, most sought after category, because in this category usually people seek protections for different literatures that they write, for different things that they write, that they express. But my dear friends, as I mentioned, it might be of a surprise for you that even computer programs are literary works. Well, to make you understand and to elaborate it further, computer programs, my dear friends, are written in the computer language. they are written in the computer language, and that is why they are called literary works. Whatever we do on a computer or on the screen of the computer is backed by a computer program to make that particular act or the activity functional. But that computer program is basically a language, my dear friends, and it is always jotted down in the language manner. So this also is a literary work and is called a literary work. Computer programs can not be given a patent protection because they fall into the category of copyright and they are the subject matter of the copyright. Well, my dear friends, I think that it is necessary for me to mention to section 3 of the Patent Act, where computer programs per se have been excluded by purview of section 3 to be given a copyright protection. Section 3 excludes computer programs per se to be given a patent protection under the Patent Act. Irrespective that they are inventions, no computer program shall be given a patent protection if it is a computer program per se, because on the computer programs a different intellectual property can be conferred, and that is copyright under the category of literary works. I have discussed about computer programs per se in my discussions on patent law, which are available on YouTube. You might refer to that discussion where computer program per se or the discussion on computer program per se lies. Now coming back to the definition of literary work under copyright law, tables and compilations including computer databases are also literary works, my dear friends. Tables and compilations. Well, let me give you an example of a table or a compilation. Suppose you have come up with a telephone directory which is mere compilation of the telephone numbers of the residents of one particular city or one particular state. Can this compilation be given a copyright protection? If we go by the definition provided here of the literary work, we are satisfied and we can easily understand that the compilation in the form of a telephone directory falls under the definition or category of literary work. So one hurdle has already been crossed, that it is a subject matter to be given a copyright protection. But it must not be copied and it must be the expression of the person, original expression of the person claiming the copyright on that. So when I will discuss with you the originality, I will tell you the detail or in the detail that whether a compilation which is original be given a copyright or not. As of now, you understand that a original compilation can be given a copyright protection and is a literary work as per this definition provided under 2O. So tables and compilations including computer databases. Well, computer databases, my dear friends, are also compilations of the data. There is a difference between computer databases and computer programs. Computer programs are basically the different back-end languages supporting the computer functionality, and computer databases are the basis or the resources where the data lies of the computer. That is also falling under the category of literary work and can be given the copyright protection as a literary work. Now moving ahead, my dear friends, and coming to the next category, that is musical work. Under section 2P, musical work is defined, and which means a work consisting of music. Well, my dear friends, I would like you to notice the word means. Whenever you find the word means written, it means it is an exhaustive definition. No other thing can be included or incorporated except what is written here. But in the previous categories, we have seen that those definitions were inclusive definitions. For example, for the literary work, we had the inclusive definition. For the dramatic work, we had the inclusive definition. But for the musical work, we have an exhaustive definition. No other thing can be included in it. So musical work means a work consisting of music. It means any graphical notation. If you see and look at the slide, the definition of the musical work is provided under 2P, which means a work consisting of music and includes any graphical notation of such work, but does not include any words or any action intended to be sung, spoken or performed with the music. Well, my dear friends, if you look the different kind of works which are called musical work, you will be surprised to note that the high quality singing or wonderful singing by a renowned singer or a melody played by a renowned singer cannot be called a musical work as per this definition under the Copyright Act. It is the graphical notation of such work which has been made the musical work to be called or given a copyright protection under this act. So a work consisting of music is a musical work, and it reads that it includes any graphical notation of such work but does not include any words or any action intended to be sung. So whatever you sing, whatever a singer sings, whatever words a singer utters or speaks or performs cannot be called a musical work. So the musical work to understand here is the work which is the graphical notation of the different rhythms or the melodies noted by the musicians. Those works are called the musical work for the purposes of this act and can be given the copyright protection. So you might be wondering by now that what about the singer who is performing? What right will he be getting after performance? Well, my dear friends, he will be getting the performer's right on his performance by way of singing. And as far as the lyrics of the songs are concerned, the literary right will be given to the lyricist for those literary work, for that literary work. And similarly, for different music instruments played by the different musicians assisting the singer to adorn the music, they will also get a right, but that right is not to be given in the category of musical work. They will get a performer's right because they are performing while playing those musical instruments. What is squarely called a musical work as per this definition? It simply reads that the graphical notation and a work which must consist the music or which contains the music is called a musical work. Words spoken, intended to be sung, performed will never be called musical work under this category. But there is no denial of protection even on those things. The protections will be available and are available, but those protections are to be conferred by purview of some other provisions of the copyright law, especially performer's right. Now, moving to the next category, friends, computer programs. Well, my dear friends, I have made it a separate category, though I have already discussed that computer programs are the literary works and they fall under the category of literary works. But I just wanted to make all of the viewers understand that what does computer program mean. Computer program mean a set of instructions expressed in words, codes, schemes or any other form, including a machine readable medium capable of causing a computer to perform a particular task or achieve a particular result. Well friends, this is the meaning of the computer program, and if you look, these are set of instructions expressed in words. These are set of instructions expressed in words, codes or schemes. So something which is expressed in words, codes or schemes, that has to be called a literary work, and that is why it has been appropriately put under the category of literary works and can be conferred a protection under the category of literary works. Moving ahead friends, and coming to second last category of subject matter of copyright, that is cinematograph films. or in short, cinefilms. Cinematograph film is a category which is defined under 2F. Well, dear friends, cinematograph film under 2F means any work of visual recording or any medium produced through a process from which a moving image may be produced by any means. I am reading it again, my dear friends. It means any work of visual recording on any medium produced through a process from which a moving image may be produced by any means. So what does it mean? I mean any moving image which is captured through a process. Say for example, the process of capturing a moving image is videography. So anyone who is videographing something and making a visual recording of images, that is a work which is called a cinefilm or a cinematograph work and falls under the category of cinefilms, can be given a copyright protection. Another thing that is called a cinefilm, it is a sound recording accompanying such visual recording. So anybody who is recording a sound accompanying with a visual recording can also be given a copyright protection under the category of cinefilms. If you look carefully in the first definition of a cinefilm, it says any work of visual recording produced through a process from which a moving image may be produced by any means. It may be a photography or it may be any other thing. Similarly, it also includes a sound recording accompanying such visual recording. Well, my dear friends, you might be having a confusion as far as, you see, this first clause is concerned, which reads that it may be a work which has been produced by any means. A work of visual recording produced by any means, by any process, except visual recording, because we all know that videography is one method of one process of capturing the images. What can be any other method or any other mean? Well, as far as this last part of this clause is concerned, my dear friends, that has been put here to broaden its scope or to widen its scope, so that videography does not remain the sole method of capturing the images. There can be many other methods of or processes of capturing the moving images or forming the moving images. For example, animation is such method from which different images or is a process. Animation is a process through which moving images can be produced. So my dear friends, even such newer methods like animation are also covered, and that is why the language has been used that by any means, any work produced by any means of visual nature or of audio nature accompanied by visual recording can be called a cinematograph work. The third category here is cinematograph here shall be construed as including any work produced by any process analogous to cinefilm, including video films. Well, my dear friends, I have just discussed with you that cinematograph is not restricted in its definition only to process of cinematography, only to process of videography, only to process of traditional form of capturing the images, that is video recording. It even includes those things which are newer techniques like animation. So whenever we read the word cinematograph, we construe it as if it covers the traditional methods or processes of capturing the images, as well as the newer methods like animation as well, which are analogous method of cinematography. They are not actual methods of cinematography, but they are analogous methods of cinematography, because even through animation a visual recording can be made, or you can say animation is a process which may form a moving image. It may form a moving image. You all have seen many new movies nowadays cinematographed through animation as a process or as a technique. not exclusively or solely by a traditional technique of videography by a video recorder or a cinematography by a video recorder. So there are several such processes available which can be opted and used for the purposes of capturing the moving images and for the purposes of producing the cine films. So my dear friends, you have to take care that a cinematograph film has to be construed in the manner in which it is written here in the definition, and this construction will prevail in the entire Copyright Act 1957, or even in those contexts where the word cinematography is to be used in relation with the Copyright Act 1957. Now coming to the next category, my dear friends, which is of sound recording. Even a sound recording can be given a copyright protection, dear friends, and under this category, you see, the surprising element is that you will notice by the definition of the word sound recording provided under 2xx on your screen, it means a recording of sounds from which such sounds may be produced regardless of the medium on which such recording is made or the method by which the sounds are produced. I urge all of the viewers to read the language of the provision very carefully and several times, because this is a ticklish language used here. A recording of sounds from which such sounds may be produced regardless of the medium on which such recording is made. In the common parlance, by sound recording we understand in the studios any sound recorded by the studio owner or the creators of the sound recording in the studio. In the common parlance we understand that it is called the sound recording. Or maybe any sound recorded by a person. Suppose you are listening my discourse here and you are recording my sound. Will you get the copyright protection on that sound recorded by you? Think over it in light of this definition provided over here. Will the studio where I am recording my sound, or the lecture is being delivered, a discourse is being delivered, can the studio owner write on my sound recording or on the sound that I am making here? Well, my dear friends, these are certain ticklish issues which I will have to decipher and discuss in consonance with certain good judgments delivered by the code of law. But as of now, at this juncture, we will have to go by the verbatim definition provided here, and which says a recording of sounds from such sounds may be produced regardless of the medium. In any medium whatsoever, if you are recording a sound from which such sounds may be reproduced later. If I have a tape recorder and I am recording a sound of one person, I can reproduce the same sound on that tape recorder by playing the tape recorder. So can that sound recorded by the person of anyone be called a sound recording and will fall under the category of sound recording and can be given a copyright protection? Because from the prima facie understanding of this definition, we get that any recorded sound through any medium, the necessary component is that it can be reproduced. Then it can be given a copyright protection and can be called a sound recording. But later limb of this provision, the later part of this provision reads that such sound recording has to be regardless of the medium on which such recording is made, and has to be regardless of the method on which sound is produced. So it's a very ticklish definition, my dear friends, and I believe that because of the paucity of time, I may not be able to take up the case laws that I have in my mind to discuss and decipher this concept. I will take it up later in the next discourse. Thank you very much and have a very good day.
With this note, thank you. With this note, thank you, sir. Thank you so very much for giving us a productive session on subject matter of copyrights. And dear friends, if you have any queries, then do write to us at info.cec@nic.in. The lecture is going to be uploaded on YouTube soon. So keep writing us, keep watching us. We would be meeting again very soon and would be discussing on another topic under the series copyright. Till then, take care. Goodbye. Thank you, sir. Thank you so very much.
Thank you very much.